Advisory. Please remember, the information provided is for educational purposes only and is not legal advice. If you need legal assistance, we recommend contacting an attorney. If you do not have access to one and want help, please reach out to Washington Law Help, a trusted resource for legal guidance at washingtonlawhelp.org. WASHingtonlawhelp.org.
Ready to dive into some serious legal waters? Today, we're tackling Washington State's Residential Landlord-Tenant Act of 1973.
Ooh, okay.
Yeah, forget those like basic renter's guides, the ones.
Right.
We're going deeper, way deeper into the nitty-gritty.
I like it.
Think security deposits, reasonable repairs, even what happens if a tenant passes away.
Wow. Yeah, most people don't even consider that.
Right. So whether you're signing a lease right now or maybe just dreaming of owning property someday, or even if you just love knowing the rules of the game, this deep dive is for you.
It's amazing how this act really does act as like this binding agreement, for both sides.
Totally.
It ensures fairness and transparency, and especially in a state like Washington with such a diverse rental market.
Right, and it's not new to the game either.
No, it's not.
This law has been around for ages, constantly evolving with amendments and updates, like the 2024 update to notice periods. It's definitely not just gathering dust somewhere.
No, not at all. This act, officially known as RCW 59.8, truly lays the groundwork for a balanced rental environment in Washington state.
Huh.
It's like that rule book that everyone agreed on,
Right.
So both landlords and tenants understand their rights and responsibilities.
Okay, so like any good rule book, it's got to start by defining the players, right?
Absolutely.
Yeah.
We've got our landlord, our tenant, the premises, but it goes beyond just those basic terms,
Okay.
Like when you think landlords, you might just picture the person collecting rent checks, right?
Right.
But the act actually broadens that definition quite a bit.
So we're not just talking about landlord Larry in a Hawaiian shirt then.
Not at all. The act considers property managers and agents, even lessers, as potential landlords. And on the flip side, a tenant isn't just the person who signed the lease.
Oh, interesting.
It includes anyone living in that dwelling unit, even if their name isn't on the lease itself.
So we're talking about specific types of living spaces too, right?
Exactly.
Right.
This act focuses on what it calls dwelling units, which are designed for people to live in. So we're talking about houses, apartments, condos, even mobile homes if they meet certain criteria.
So we've got our players, we've got our playing field. What about the rules? What are landlords' obligations according to this act?
Well, it goes beyond just cashing checks every month. Landlords have a legal duty to maintain a safe and habitable space for their tenants.
So we're talking beyond just fixing a leaky faucet. What does the act actually consider a landlord's responsibility?
Think structural integrity. Roofs, floors, walls, that's all on the landlord. Then you've got those essential services like heating, ventilation, plumbing. All of that needs to be not just functional, but safe and up to code.
Right. It's not just about keeping up appearances. It's about making sure the place is actually livable.
Exactly.
And you might think just general upkeep is enough, but this act gets super specific.
It does.
Like, it's not just about having a working heater. It has to be safe and up to code.
Yeah.
That's where something called a certificate of inspection comes in.
That's a great point. A certificate of inspection is basically like a verification that a property meets those very specific safety and health standards. And local municipalities in Washington can actually require landlords to obtain these certificates.
Wow, so it's like another layer of regulation.
Exactly. It's like a stamp of approval that a landlord is following the rules, which of course can be very reassuring for tenants.
Totally. Like, okay, this place has been checked out. It's good to go.
Right.
Especially in like a multi-unit building or something.
Oh, absolutely.
You'd want everyone to be on the same page about fire exits, smoke detectors, all of that.
It's all part of the landlord's duty to provide that safe and habitable environment, which is really a cornerstone of this act.
Okay, so we've talked about landlords and their responsibilities. What about the tenants? What are their duties? Because it's not all about just paying rent on time, is it?
Not at all. While paying rent on time is obviously essential, the Act outlines several other tenant duties that contribute to a respectful and functioning rental agreement.
So it's like being a good and responsible roommate, but with legal backing.
Exactly. Think basic upkeep. Keeping the living space clean, disposing of garbage properly, using appliances and facilities responsibly. It's really about preventing damage beyond normal wear and tear.
So no using the oven as a storage unit
Probably not a good idea.
or turning the bathroom into a slip and slide.
Right. The key takeaway here is that tenants have a responsibility to treat the property with care, just like they expect their landlord to maintain the property's basic functions.
It's about finding that balance, right?
Yeah.
Both sides upholding their end of the agreement.
Exactly. And just like landlords, tenants are also bound by any local codes and regulations. The rules apply to everyone you know to ensure that safe and respectful living environment for all.
It's a two-way street, which makes sense. You're living in a shared space, so everyone needs to be on the same page.
Right.
Now, even with the best intentions, disagreements can happen. That's where the Act's section on handling disputes comes in handy.
Oh, for sure.
Let's face it, not every landlord-tenant relationship is smooth sailing. Sometimes you need a little legal guidance to navigate those choppy waters.
Absolutely. And the Act really stresses the importance of communication and good faith effort from both parties.
Right.
For instance, if a repair is needed, tenants have to notify their landlord in writing.
So no more passive-aggressive sticky notes on leaky faucets.
A written notice is definitely more effective, and landlords are held to reasonable timelines for addressing those repairs.
So it's not like they can just say, we'll get to it when we get to it.
Nope. The Act actually outlines what constitutes a reasonable time frame for different types of repairs.
Yeah.
This prevents landlords from dragging their feet.
But what if a landlord is dragging their feet on a repair even after a written notice? What recourse does a tenant have?
Right.
They can't just withhold rent and hope for the best, can they?
Well, they can withhold rent, but it has to be done legally and strategically. The Act provides tenants with a few different options. They can pursue legal action, withhold rent under very specific guidelines, or even request a government inspection to document the issue.
So tenants do have options, but it's not something to try at home. You really have to understand the proper procedures.
Exactly. Knowing your rights and the proper channels to address grievances is vital for both tenants and landlords.
Absolutely. Speaking of knowing your rights, let's move on to a topic that can be a bit more serious: evictions. I think there are a lot of misconceptions surrounding the eviction process.
Definitely. It's important to remember that in Washington state, evictions are a legal process with very specific rules outlined in the Residential Landlord-Tenant Act. It's not as simple as a landlord deciding to kick someone out just because they feel like it.
Right.
There's a process.
So what are some of the valid reasons that a landlord might be able to file for eviction?
Well, non-payment of rent is a big one, obviously.
Yeah.
But it also includes things like violating the lease agreement. Think unauthorized pets or subletting, or engaging in illegal activities on the property.
Okay, those seem pretty straightforward. But even if a tenant is facing eviction, they still have rights during that process, right?
Absolutely. Tenants have the right to receive proper notice that's non-negotiable. They also have the right to contest the eviction in court and present their side of the story.
So it's not an automatic out just because the landlord initiates that process?
Not at all.
Yeah.
And this is where having some kind of legal representation can be really crucial for tenants,
Yeah.
especially those who might not be familiar with all the intricacies of the law. Having someone on your side who speaks legal can be really invaluable in these situations.
That makes sense. Now, before we get into the nitty-gritty of tenant screening and recent changes to the Act, let's take a quick pause. When we come back, we'll delve into even more fascinating aspects of Washington's Residential Landlord-Tenant Act. Don't go anywhere.
Welcome back. Before the break, we were just about to unpack the often murky world of tenant screening.
Right. It feels like a process shrouded in mystery for a lot of renters. Like, what are they actually looking at? What are they allowed to use against you? You know, it can be kind of nerve-wracking.
And for good reason. That's why the Residential Landlord-Tenant Act lays out these really specific rules to make sure that it's fair and transparent for everyone in Washington.
So walk us through it. What are the key steps that a landlord has to take when screening potential tenants?
Well, first off, no more surprise credit checks. Landlords have to provide a written notice to all prospective tenants outlining the entire screening process before they even think about pulling a credit report.
So communication is key from the get-go. What kind of specifics need to be in this notice?
It has to be very comprehensive. We're talking about types of information they'll access: credit reports, a criminal history, eviction history, rental history. It's all got to be laid out. Plus, they have to specify the criteria that could lead to an application being denied.
Okay, so if a landlord has a strict no pets policy, for example,
Right.
or requires a certain income level, that has to be stated up front.
Absolutely. Transparency is crucial. It allows potential tenants to self-select out if they know they won't meet the requirements,
Sure.
and it prevents any surprises later on.
What about the cost of all these checks? Can landlords just charge whatever they want for running these reports?
Not at all.
Yeah.
There are actually regulations around that too. Landlords can only charge prospective tenants for the actual costs that they incur for obtaining those reports.
Oh, wow.
We're talking receipts required, folks.
Okay.
And the charges can't be excessive.
Mm-hmm.
They need to align with what screening services typically charge in that area.
So no sneaky inflated fees just because they think they can get away with it.
Exactly.
Right. It seems like a good way to prevent landlords from, turning a profit on the screening process itself.
Right.
Okay, so we've been talking about that more traditional background check route. But I understand that Washington State has something called a comprehensive reusable tenant screening report.
They do. It's a relatively new addition to the Act, and it's actually pretty innovative. It's essentially a tenant-driven report.
Tenant-driven. So instead of the landlord requesting all of this information, the tenant takes the lead.
Exactly. A prospective tenant can pay a consumer reporting agency to compile this comprehensive report, which includes everything we just talked about. Credit reports, criminal history, employment verification, rental history, you name it.
Wow.
And the tenant controls who gets to see it,
Oh, okay.
and it's free for landlords to access.
So it's like having your rental resume ready to go,
Exactly.
which could be a game changer, especially if you're applying to multiple places.
Oh, absolutely.
No more filling out the same forms over and over again or authorizing multiple background checks.
Exactly. It really streamlines the whole process and gives tenants more control over their information.
But even with this report, landlords still have to follow those same criteria they outlined in that initial notice, right? Absolutely.
They can't just decide they don't like your taste in music based on your credit card statement or something.
Right. The same rules apply. They have to base their decision on the criteria they listed up front, not on any arbitrary factors.
Fair enough. It's all about maintaining that fairness and transparency throughout the process.
Now, even if a landlord follows all the proper steps and acts in good faith, there are times when they do have to make these tough decisions.
Right.
And that's where the adverse action notice comes in.
So if a landlord decides not to rent to someone, they can't just ghost them. They have to provide an explanation.
They do. The Act requires landlords to provide a written notice explaining the reason for that adverse action.
Okay.
No more wondering why you didn't get the place.
That's got to be a relief for prospective tenants just to at least get some closure,
Right.
understand what went wrong. But it can't just be some vague, it wasn't a good fit type of thing, right? It has to be specific. The notice has to clearly outline what factor or factors led to that decision. Was it something on the credit report, the rental history, a criminal record? It's all got to be spelled out.
Okay.
And they even have to include contact information for any reporting agencies they use so tenants can already check the accuracy of that information.
Which is a good reminder that everyone has the right to dispute inaccurate information on their reports.
Oh, absolutely.
Sometimes a simple error can make a big difference.
Mm-hmm.
Okay, so let's shift gears a little bit here. We've talked a lot about what happens when things go wrong, but what about when life throws, those unexpected curveballs?
Right.
That's where the landlord mitigation program comes in.
Exactly. This program is a great example of how the Residential Landlord-Tenant Act really goes beyond just the basics and tries to address some of those real-world challenges that we see in the rental landscape.
So what is the purpose of this program? Who is it designed to help?
It's designed to offer a safety net for both landlords and tenants when a tenant is facing specific hardships that make it difficult or even impossible to pay rent.
And I can see how this would be especially relevant in a time like now when so many people are facing financial uncertainty, whether it's due to, job loss or unexpected medical expenses, things like that.
Absolutely.
Right.
And while the program itself isn't tied to any specific event, it can be a vital lifeline during those unexpected tough times.
So how does it work? If a tenant is struggling, can they just apply for this program and have the government cover their rent?
It's not quite a direct payment to tenants. The program is actually designed to reimburse landlords under specific circumstances.
So it's more of a partnership then?
Exactly.
Between the landlord, the tenant, and the state to keep people housed during a crisis.
It helps landlords recover some of that lost income while simultaneously preventing tenants from ending up on the streets.
Now, I imagine that there are a lot of specific eligibility requirements for both landlords and tenants to qualify.
There are
It can get a bit complex, and we don't really have time to unpack all of the nuances here.
Right. But it's
Yeah.
definitely worth looking into if you're a landlord or a tenant facing a situation where rent payments are a concern.
Absolutely. Knowledge is power, especially when it comes to navigating these kinds of complex situations. If you want to delve into the nitty-gritty details, you can look up RCW 43.31.605. That's the specific section of the revised Code of Washington where you'll find all the ins and outs of the landlord mitigation program.
Consider it added to the reading list. It's amazing to me how this one act, the Residential Landlord-Tenant Act, tries to cover so many bases,
Yes.
and create this framework for handling all of the complexities that come with renting.
It's a reminder that this act isn't just about rules and regulations. It's about finding solutions that work for both landlords and tenants, especially during challenging times. And that's something worth remembering.
For sure, we've covered so much ground already, landlord responsibilities, tenant duties, navigating those disputes, even that safety net of the landlord mitigation program.
Right.
But this is the deep dive, so we're not quite done yet.
You're right, we're not. The Residential Landlord-Tenant Act goes beyond those kind of everyday scenarios.
Okay.
It actually addresses situations that require, extra sensitivity. It's about recognizing that real life isn't always straightforward, and the law needs to reflect that.
Right. It's about those special circumstances that might not even cross your mind until you're actually facing them.
Exactly.
So what are some examples of those more unique situations that the Act covers?
We touched on how the Act protects service members who might be facing deployment or relocation.
Right.
It allows them to break leases under certain conditions. But it also extends protections to victims of domestic violence,
Right.
recognizing that sometimes that need for safety has to come before a standard lease agreement.
Of course, it makes sense that those situations would require a completely different approach. So what kind of protections does the Act offer in those cases?
Imagine a tenant is trapped in a dangerous living situation, right?
In Washington, they actually have options. Under specific conditions, victims of domestic violence, sexual assault, stalking, they can legally break their lease agreements early without facing those financial penalties.
Wow, that's huge.
Right.
It gives them a chance to prioritize their own safety without being burdened by that lease.
Yeah.
But I imagine there must be some safeguards in place to prevent abuse of that provision, right?
Oh, absolutely.
Yeah.
The Act does require victims to provide documentation to qualify for that early termination.
Okay.
So that could be a valid order for protection, a police report, a documented record from a qualified third party, like a domestic violence shelter.
So it's about finding that balance again,
Right.
right? Providing a lifeline for victims while still maintaining some level of accountability.
Exactly.
It's reassuring to know those protections are there, even if you hopefully never have to use them.
Couldn't agree more.
Yeah.
And on top of that, the Act also protects against landlords discriminating against someone just because they are a victim of domestic violence.
Oh.
So they can't refuse to rent to someone just because they terminated a lease early due to those circumstances.
That's good. It would be awful if someone was penalized for, seeking safety.
Exactly.
It's all about breaking those cycles. Okay, shifting gears a bit here, let's talk about another sensitive situation that the Act addresses, and that's dealing with a deceased tenant's belongings.
Right. This isn't just about logistics. It's about handling a delicate matter with respect and compassion.
Of course.
And the Act outlines a really clear procedure that landlords have to follow.
So it's not like in the movies where a landlord can just waltz in and start clearing everything out?
Not at all. It's a very structured process.
Right.
The landlord has to make a good faith effort to actually locate and notify any known heirs or legal representatives of the deceased tenant's estate.
Oh.
And it's not just about, slapping a notice on the door either.
Yeah.
The Act outlines specific methods and timeframes for those notifications.
So it's all above board, providing that transparency and hopefully some peace of mind.
Exactly.
But what happens if no one comes forward? Those belongings can't just sit there indefinitely.
You're right. They can't. The Act addresses that as well. After a certain time frame and following very specific procedures, the landlord is legally allowed to sell or dispose of the property.
Okay.
But again, it has to be done transparently and lawfully, with any proceeds from a sale being handled according to state guidelines.
Mm-hmm.
It's all about protecting the rights of everyone involved, even in death.
It really is a reminder that even though we're talking about a legal document, the Residential Landlord-Tenant Act takes into account the human element of these situations.
It does.
It's about fairness, transparency, and compassion, which is pretty impressive for a document full of legal jargon.
It really is. Throughout our deep dive today, from those basic landlord and tenant responsibilities to the more sensitive situations we discussed.
Right.
One thing is clear. Washington's Residential Landlord-Tenant Act aims to create a fair and transparent playing field for everyone involved in that rental process.
It's like having a roadmap to navigate this sometimes complicated world of renting. We've unpacked so much today, from security deposits and repairs to evictions and tenant screening, even the ins and outs of the landlord mitigation program and those crucial special provisions.
And yet we've really only scratched the surface.
Right.
Laws are complex, ever-evolving things, and this deep dive is just a starting point. If you're ever facing a specific situation, it's crucial to seek legal advice from a qualified professional.
Expert speaker is absolutely right. Don't just rely on internet forums or hearsay. Get personalized advice tailored to your specific circumstances. Consider this episode your jumping off point,
Excited.
for further exploration.
Knowledge is power, especially when it comes to navigating the legal landscape of renting.
And with that, we've reached the end of our deep dive into Washington's Residential Landlord-Tenant Act of 1973. We hope you've gained some valuable insights today and maybe even a newfound appreciation for the intricacies of renting in Washington state. Happy renting, everyone.
Disclaimer. This audio production was generated by artificial intelligence from input generated by humans. There may be unintentional errors. The errors in this audio are minuscule and do not affect the overall understanding of the document RCW 59.18, also known as the Residential Landlord-Tenant Act of 1973. The errors have been left in for authenticity and transparency. Listeners are encouraged to point out these errors and correct them in the comments section of this video or podcast. This promotes community involvement in an important discussion that directly affects almost 3 million people in Washington state, over a third of the population. Thank you.